Hear ye, hear ye, hear ye. All persons have business to do before this court. All persons who attendance, it shall be heard.
Thank you. Please be seated. The first case on the calendar for oral argument this morning is People v. Harris, case 204. Both attorneys will be arguing remotely. We have counsel ready. Ms. Healy, you may begin.
Yes, Your Honor. Thank you very much. May it please the court, Harmony Healy on behalf of the people. The lower court here erred in dismissing the murder indictment based on an alleged violation of Section 4040. It's our position that this was error for three different reasons. My first reason is that the lower court erred in determining that the possession of the weapons that defendant was caught in possession of on the day that they caught her was a separate criminal transaction from the murder that had occurred on the day before. The second reason is that there was not legally sufficient evidence to support an indictment for the homicide until we received the DNA results back. And the third reason is that it led to an inequitable outcome in the dismissal of a homicide charge. So with respect to the first point, the separate criminal transactions, it's been pretty clear from the cases that have come down, both I think from the Court of Appeals as well as the departmental cases, that it's kind of a fact-by-fact inquiry, that it's going to be a little bit different under the facts of each case. And the facts of this case are that 911 was called, and it was called because there was a woman who was standing naked with her arms kind of smashed through the windows of the front door. And when first responders responded and got there, she was still there with her arms through the door and was making several allegations that someone had broken into her house that night. She was making allegations that the police were there to kill her. But the one thing that she admitted to pretty unambiguously and unwaveringly was that she had possessed those weapons for at least the last 3 months prior because
Ms. Healy, can I, we understand what the evidence is here, what the record says. Can I ask you a question here with respect to the grand jury minutes?
Yes.
And it deals with, not with conceptually or theoretically, could she have been charged? Were they separate criminal transactions? Could they have been? But what was the evidence for the grand jury on the firearm offense? What was the theory presented? What was the evidence presented to the grand jury as to when the possession took place? What would you say? Before the shooting? You wouldn't say during the shooting, of course, or was it after the shooting? Which one?
I believe it was after the shooting because it came into play when they arrived at the scene.
Okay, so all the talk in the motion papers from your office about her admissions that she possessed the gun in the past and played with it, those occurred before, those are irrelevant to our consideration, right? Because the indictment alleges it occurred after the murder.
So I think the admissions to her possessing them occurred when the responders were first on the scene.
Right, but what I'm saying is that the indictment here for the weapons offense alleges that it occurred on a date subsequent to the murder, right?
I think on the date after.
Excuse me?
I believe that the charges came out. Oh, I'm sorry.
Right, the indictment for the CPF alleges she possessed the two firearms on the day after she murdered her grandmother, allegedly.
Yes.
Right? Okay.
Correct.
So in the record we see in the police reports, there's a lot of talk about she made admissions, made statements about possessing it in the past. I've always played with my grandfather's gun. All those things that occurred before the murder are irrelevant to us because she's charged with possession after the murder, right?
Correct.
Okay. So then my question is, what evidence at the grand jury is there of a post-shooting possession? Of the revolver. I'm not talking about the firearm upstairs, I'm talking about the revolver next to her grandmother's body.
The evidence that was presented at the grand jury was the fact that they caught her on that day with the weapons.
Okay, not in direct possession, but she was in a house with a weapon, so it was constructive possession.
Correct.
Would you agree then that that was a continuous offense, that as long as she had been in the house, that possession started even before the shooting?
I do agree that it was a continuing offense.
It continued through the shooting and then after the shooting?
Yes.
Even if she never picked up the gun at all?
Yes.
All right, so it's one continuous possession that started when she got in the house, in the same house with a gun, and it continued until the police took her out of the house.
Correct.
And the shooting took place during that one continuous crime.
It did take place during that one continuous possession.
Yes.
Yes.
Okay.
And I guess that kind of illustrates the problem that we have in this case, because you have a continuous possession that spans over a 3-month period. And so,
Well, not necessarily, if she stepped outside, if she went to the store, then the possession ends.
well,
And it
so I
starts
don't-
again when she gets in the house.
I guess I don't really know that's necessarily the case under your case law. I think that you just recently published a case on January 31st, People v. Hills, and that involved a continuous possession case. And one of the possessions of the weapon was dismissed as a violation of the double jeopardy clause. Defendant there was charged with, or was found to be in possession of a weapon 2 weeks after the commission of a homicide. When they charged him with the possession of the weapon, during the murder indictment, they held that he couldn't be charged twice for the same weapon, right? And so
Right.
I don't think necessarily in that case, and of course you would know the case better than I would because I wasn't there, but
I was on that one. Yeah, in that case, it's different in that the possession was unlawful because it was outside his house. And the question was, did he ever return to his house? Was there any evidence? But in any event, so your position is that this is one continuous possession or of the weapon that occurred for months and months. The alleged murder occurred during the course of that continuous possession, and therefore, yet nevertheless, they're still separate criminal transactions.
that is my position, and the position is that because it kind of gives rise to the question that what happens if they come into the house and the grandmother has been dead for 2 weeks and they catch her with the weapons, and what if she had stepped outside during that time? This is giving rise to questions that we don't necessarily know the answers to, but you're in a situation like that, you have a continuing possession over a span of 2 weeks, and maybe you have, when do you draw the line there, right? Like, so if the body had been there for 2 weeks, is that one separate criminal transaction? You know, where
Would you agree with me on this? Is that it's not what could have been charged based on evidence that the police had, it's what was actually charged to the grand jury. We have to look exclusively at the testimony for the grand jury and the evidence. There was one body cam video. And I don't see, maybe you can point me in the right direction, but I don't see any evidence that was submitted to the grand jury that talked about her pre-shooting possession. Like, I had the gun, I was in the house with it, and I had it, played with it all the time. Was there any evidence of that in the record for the, in the grand jury testimony or evidence?
I would have to double check that.
Yeah, I would. I didn't see it, but I don't, I don't know. I didn't see it. It looked like to me, the only evidence at the grand jury, they didn't admit her statements to the police when she was questioned, right, at the grand jury?
I don't know whether they did.
Yeah.
I know that he was being particularly cautious because some of the statements were spontaneous at the
Right.
time that the police arrived, and some statements were made when she was at the psychiatric facility. And I think that he was attempting to be cautious with what statements were introduced because he didn't know whether or not they were going to be admissible down the line.
Okay.
And that kind of goes into the second point of the legally sufficient argument, or the legally sufficient evidence. So if I could just introduce that part as well, or move on to that point, if that's okay.
Ms. Healy, I'm going to slow you down for just a minute because I've got one question at least that I want to ask you.
Sure.
Now, can the people prove beyond a reasonable doubt defendant's murder of decedent by shooting her on November 20 without evidence that defendant possessed the murder weapon on November 21?
I think that you could do that with evidence that she possessed the weapon on the 20th and continuously based upon her statements.
Having looked at the grand jury testimony as best I could, it did not appear to me that evidence of the plea or conviction or any reference to that possession on November 21 was introduced before the grand jury vis-a-vis its review of the murder indictment. Is that correct?
Yes.
Okay. That's all I have for those. For
I
that.
think, remaining on the same criminal transaction, because I think that's your better argument than legally sufficient evidence, just
Sure.
my view. But do you think your office could have charged by way of separate indictments. You had just said that there's a possession before the shooting, during the shooting, and after, separate days. Could they have charged the two weapons offenses in different indictments based on, well, one, she possessed after the shooting because she remained in the house, so she had constructive possession of them. And look, she admitted she had it before. So we got two separate criminal transactions. Could those have been charged separately and prosecuted separately and sentenced consecutively?
No,
Why is it different for the murder then?
because I think that you need the possession of the weapon on the day in order to prove the murder. That's the only way that you get there.
Okay. We want to talk about the legally sufficient evidence. It seems like she admitted that she may have shot. She admitted she was the only one in the house. The body was found there. Neighbors had heard shots the night before. She had been making some threats and so forth. Your position is that without that DNA evidence on the gun, they did not have legally sufficient evidence. I'm not talking about beyond a reasonable doubt, but legally sufficient evidence to get an indictment on the murder?
Yeah, so I think that they did need the DNA results to demonstrate that she had possessed that weapon based on the statements that she made, the equivocations of the statements that she made. There were points in which she was saying that there were other people in the house and that she had heard them. And then there were points that she was saying that she sometimes played with the gun and maybe there wasn't anyone else in the house. And
All right, so if the DNA evidence came back inconclusive, let's say she wiped down the gun, there's no DNA evidence. You're saying they could never get an indictment for her based on all that other evidence, all her admissions, all the circumstantial evidence. Without that DNA evidence, they can't even charge her. That seems to be what you're saying. And if that's true, then there's a lot of prisoners who will read this decision if we go that way and be moving for re-argument on their convictions.
right. I mean, no, I think that you could have proven the case, but I think that in order to make sure that we had the right person,
Right, so you're going from legally sufficient evidence to beyond a reasonable doubt. I get that you wanted that evidence, but that's not the standard. It's, do you have enough to charge legally sufficient? It sounds like you just said that they did have legally sufficient, which undermines the entire point two of your brief.
So I think that you could, like I said, I think that you could prove it, but I think that you need those things to support and corroborate it. I think the grand jury requires corroboration and you can't just put her statements in. And certainly it would be kind of a misstep to put statements in when you don't even know if they're going to be admissible based on where she was located. I think that they definitely needed the ballistics results because the ballistics results tied the gun to
They had that though. They had the ballistics.
So they did have that, and I guess it sort of brings, in my mind, rise to another question, which is what happens if on June 27th we get those ballistic results and we don't have it scheduled for grand jury until July 20th, and on July 1st, defendant goes in and pleads guilty. And so I guess that's what I'm saying. What is the point where we are able to get that evidence and when they're able to go in and plead guilty as kind of like a trick on the court or,
Right.
like this is kind of like the gotcha that the statute is designed to present or designed to prevent. This is what defendant did. It was never unclear that we were going to.
The other side says that the strategy and the gotcha was the other way, that your office charged the weapons to get a conviction or a plea on that to be used later, even though it wasn't submitted to the grand jury. But have you seen? There's plenty of cases where appellate courts, Court of Appeals and Brown and other cases, we've had talks about concurrent consecutive sentencing for possession of a weapon, simple possession, not intent to use, and the actual shooting. There's a lot of those cases. Are you aware of a single case where for consecutive concurrent, where they were charged in separate indictments and prosecuted separately, like we have here in the history of the state of New York?
I mean, I'm not aware of anything like that. I guess that's why this is sort of a case of first impression, and there's not anything directly on point that I can see. I think it's a case of first impression because the continuing possession as well as the simple possession is a little bit newer in terms of when the legislation was passed. And so I don't know that there's been a case where you have a lapse in between other than this People v. Hills case, which was just decided, but that obviously is on a different issue. But when it comes to the continuing possession, I don't think that this has ever been answered before. And so that's why here.
And Ms. Healy, just so I have it right on point 2, you do not need to prevail on that point 2 in order to still prevail on your argument. Do I have that correct?
That's correct. I can prevail under the point 1, which is the
For the same criminal transaction.
Correct.
And did you actually, to my knowledge, you did not actually indict the defendant for any sort of form of continuous possession. It was just single possession of the 2 firearms on the day after the murder.
That's correct.
And so you indicated earlier that you thought that the people would be in a position to prove beyond a reasonable doubt without that conviction or without the proof of the day after to show that the defendant possessed the weapon that ended up in the shooting of the decedent on the day before. That's how I understood it, but if I've had that wrong, I'd like to know.
I guess I think that makes it a little stronger, but I think that the fact that she was caught in possession with the guns on the day after. So certainly we still have her admissions, which again are sort of equivocal, but you have her saying when she gets to the psychiatric hospital, I play with those guns sometimes, and it may have been that gun that led to my grandmother's death. I hope it wasn't that. So,
And Ms. Healy, just to follow up on Justice Curran's question, I'm sorry to cut you off, but as Justice Curran was alluding to, I shouldn't put words in his mouth, but the simple possession, because it's criminal possession of a weapon, not criminal use of a weapon, the criminal possession of a weapon was a separate, distinct, and completed act as opposed to the impending homicide, correct? That's what you're
Correct. That's my argument.
Wait a minute, I thought you said it was a continuous, not a completed act.
I'm sorry.
Continuous.
I think that it can be completed though. I think it's both, right? So I think that you can have the completion of a criminal possession of a weapon, but there are also cases in which then it's demonstrated to be continuous. And I think under the facts of the case here, it could be either way. And that's where you end up in that kind of weird middle area and that's why I think that there's nothing directly on point because this is a different statute.
Right, I'll give you that. It's a close issue. It doesn't seem to, it's ever been tried before, but it sounds like if we accept your rationale, then you could do this in almost every murder case with a gun. That's what Brown basically tells us. For consecutive concurrent, as long as the only way you can't get consecutive in Brown is if you form the intent before you pick up the weapon, before you possess it. Most of our murders, somebody driving around on the street in a corner, whatever, the possession started before the intent was formed. But if what you say is true, the DA could charge separately in different indictments, every CPW with a murder or homicide. And in this case, you could have charged you could have charged separate CPW or criminal possession of a firearms, one before the shooting and one after in separate indictments and gotten consecutive time, right? That's your theory.
That's my theory.
And the other side of the coin is, Ms. Healy, if we don't accept your argument, then it almost seems like we're requiring that every time that something like this occurs, you must indict each and every time the CPF with respect to the murder, or you're going to lose the chance to prove either one. So it could end up in delays, and so it's almost like if we do the opposite, we're going to establish a mandatory rule, where if we do the former, we might have a flexible rule. I'm not sure I have that right. I've got to think that through, but that's the first thought that occurs to me as I'm sorting this out.
Yes, Your Honor, thank you. And I guess that's what I'm saying when this begs the question that how far is this going to go? And I think that the cases say that you do have some flexibility because it is an equitable statute. There are cases where 48 hours between drug sales to the same person at the same location at the same time with the same drugs, those can be separate transactions. And so I think that this is going to be something that could fall under, the guidance of that. And if you don't follow that guidance in this type of case, you're going to end up with kind of maybe potentially cases being presented to the grand jury before they're ready to present them. And that's not an equitable conclusion here, particularly in this case where there was no gotcha by the people. That wasn't what happened here at all. The defendant was always on notice before she took that plea that the murder charges were coming, that we were just waiting to get the additional evidence. And so
Right, but
I
couldn't
think
you
that when you
done,
look at the circumstances of
don't
this
you,
case,
what we see often is you get a superseding indictment. If new evidence comes in, you don't need to indict separately, but, yeah, it's a really interesting issue, kind of like a law school question, and we appreciate your arguments today.
okay, thank you very much.
Thank you.
Good
Counsel?
morning, Your Honors. Nicholas Texedo for Ms. Harris. Judging by the questions, I'm going to focus on the same criminal transaction issue, which is one of the 4 prongs that would have to be met for dismissal under this statute. Your Honors, this is a possession that took place from before the murder and through after the murder. She's charged with on or about the 21st, which it's one continuous exercise where she is allegedly in the house possessing the guns, shoots the grandmother with them, continues to possess them, and then is arrested some hours later. So there's a difference between there being 2 separate acts for the purposes of consecutive sentencing or concurrent sentencing and same criminal transaction, which is a more broad category. It's things that fit together in terms of time, circumstance of commission. Here we have a weapon that is ballistically shown to be what murdered the person who was killed. So to say that possessing it continually throughout that incident is not part of the same criminal transaction, I don't think would be correct, frankly.
The statute is a little broader than that. It says same criminal transaction are so closely related in time and circumstance as well. But what if they just indicted her on the pistol upstairs? That it sounds like it was just a constructive possession theory, and then charged her with the murder and the possession of the other weapon that was used in the homicide. No problem there, double jeopardy?
So the pistol that was not used and only charged that one, it probably would have been smart. I think it would have made my argument a lot weaker. I don't know if I can say that there wouldn't be an issue. I'd have to think it through, but I understand what Your Honor is saying, that would,
if you could
that
do
would have
one,
a significant impact on
maybe
the
both, yeah. I mean, it's kind of hard to parse out one from the other, but do you see any evidence in the grand jury that showed possession, actual possession, not constructive possession after the shooting? Any statements she made? Any evidence that the grand jury, because we need to know what the grand jury was voting on. What theory?
Yes.
Was it?
So
It sounds like the before theory that was argued below by the people is out the window. I
right.
think they just threw it out the window today. It was already on its way out the window, I think, before that, when they filed the indictment. But now they're focused on post-shooting possession. That seems to be their theory. After the shooting, she put the gun down. It was found next to the grandmother. She's in the house, the defendant is. So she continually possesses it up until the time she's taken out by the police.
Yes, that's what the evidence shows. There's no indication that she picked it up and had actual possession at any point after the shooting. There was no admission to that, no indication of it. So it would be a continued constructive possession. There was no evidence that she left the house or that there was no evidence of any break in possession, I guess I would say.
And Mr. Texaco, I don't really read your brief as relying on this concept of a continuous possession thing anyways, right? I mean, maybe I missed it, but I don't remember that being in your brief. Am I correct on that?
No, not per se, but I'm kind of answering the questions going
Understood.
the way it's led. But I would say, I mean, the concept that she possessed the gun through the before, during, and after the homicide, And that's what the evidence would show. That runs throughout my brief. And so
right.
maybe without using the word continuous.
No, I understand. That's fair in the context of the questioning. But I saw you going down that path, and I didn't see it in your brief, and I wanted to just make sure I got that right. With respect to the record, to make sure I have this right as well, and if I don't, I need to know. I'll go back and look. But I saw nothing in the grand jury testimony or evidence that indicated that the people were relying upon the plea or conviction to the weapon possession of the revolver involved in the shooting when they presented to the grand jury. Do I have that right?
That is correct. They did not put evidence in of the plea.
And even though Ms. Healy has said that it would be more difficult, she answered my question where I said, yes, they could prove it without any reference to that conviction or plea for the possession of the involved revolver on November 21 to prove the shooting with that revolver on November 20. Do you agree that they could, well, not that they would, but it is theoretically possible to prove their case without any reference to that conviction or possession on the 21st?
Without any reference to the conviction, sure. Without any reference to the possession, no.
Understood. I think you have to find.
That would be our answer. And I would just like to briefly address the equity argument, where it's, the word gotcha is used here. Your Honors, this plea was 4 months after the prosecution received the lab report. So the questions of what if it was 48 hours, it's really not something the court needs to determine here. They had it for 4 months. And in the record attached to the motions are then district attorney indicating that the reason he held back on the murder was for strategic considerations. And that's him telling the media that. Now, lastly, on that point, it could cause problems throughout the state if the prosecution was allowed to do it this way and have a lower stakes suppression hearing. And as the court's aware, whether you even want a statement suppressed, what you might try to accomplish at a hearing, that is all dependent on what you're charged with. You could be charged with one thing and your statement really hurts you. You could be charged with something else and you could not mind if that statement comes in. So,
Mr. Texco, just in response to that, I'm having a little trouble with the equities of the policy argument on your end, because this does sort of strike me as a gotcha moment, perhaps, but I see your point. But tell me why it is that the rule, if we were to go your way on this, that we wouldn't essentially be requiring that the people indict all this together as soon as possible, or else risk on losing out on double jeopardy grounds under the statute. It seems to me we would establish a very strict mandatory rule if we went your way, and yet we'd be doing so in a case that is so singular, as our Justice Presiding pointed out. So why should we go that way, your way, when it would be much more flexible to go the other way?
well, so Your Honor, this was all within the prosecution's control. This wasn't a case where Ms. Harris was charged by felony complaint or misdemeanor complaint. It wasn't a situation where she could plead guilty to these weapons offenses unless and until they indicted her on those and did not indict her on the murder. So it was all within the prosecution's control. As far as requiring them to indict it together, yes, I think the statute does, because it's part of the same criminal transaction. And I think the policy reasons underlying that the legislature must have found outweigh the negatives.
They could charge separately talking about future cases, they could charge separately if there's not enough evidence to get an indictment on a murder charge. They could go with the CPW.
Yes.
They could wait, they get superseding. They could get a superseding indictment, they could get a new indictment if there's not legally sufficient. If we agree with you that there was, though, then they couldn't. If we were to affirm this, we would say, and it seems like, I don't think this has ever been done before, ever, on a CPW and a homicide or a shooting, where they parsed it out this way.
Right.
If there's legally sufficient evidence, but there's always a first, and it doesn't mean that because nobody's done it that they can't do it. So But
Right.
there is that. It's not like, I don't think this is going to happen very often. I mean, it's
No,
pretty
I
pretty risky strategy to do this, and for no evident purpose. It's not like they gave her probation on the weapons offense. It's not like they were getting her off the street.
Right.
Doesn't seem to
There was
be
no
any-
urgency to that. I don't know what their reason was. All I know is the effects that it could cause, such as having someone not qualified to handle homicides doing a hearing that's going to be binding on a later homicide. Things of that nature. Those are the effects. I can't speak to their purpose and why. I would candidly tend to think it was a mistake, frankly. However, what I'm looking at is the requirements of CPL 4040. And if you go through one by one, it's our position that all four are met. Unless there are any further questions, we will rest.
Thank you.
Thank you, Your Honors.
Case number 206 is next. It's People versus Brian Smith. Counsel, good morning. We're waiting. Oh, Ms. Healy is here on this one, so she is ready to proceed. So you may start. Thank you.
Good morning, Your Honors. Alton Mathewson for Mr. Smith. May I please the court? Because the people considered that the sentence was illegal in this case, I would just focus on the mootness exception. If this court agrees that Mr. Smith's sentence was illegal, it would provide guidance to many sentencing courts in a situation that would be likely to repeat. So here what's at issue is the application of Penal Law 7030, so the credit for the incarceration term that could apply to the probation term on a split sentence that arise from two different convictions and two different...
The people have conceded that there was a couple problems in this case.
That's correct.
So we're sort of beyond the nature of the error, right?
That's correct.
So now we're looking at the remedy.
That's correct.
And the people, I think, submit that the remedy is really moot because the sentence is completely served, as frustrating as that may be or may not be, because I'm not sure it would have made any difference if it had been done differently from the get-go. But how do you don't seem to dispute that this is moot, but you seem to say we should have an exception to the mootness. Do I have that right?
That's correct, Your Honor.
Why
Does
is
this,
that?
does this happen a lot out there? Is this going on all the time where somebody gets a year and then they get consecutive probation? Because the statute's crystal clear that you can't do it. So it's not like anybody should need any direction from us. You can't do, the legislature's already said you can't do it. But my question is this a problem that's rampant out there in the trial courts and local court?
I think that's an issue. It has been 40 years ago since this court said that you can do it. And Mr. Smith was sentenced in 2019, so I think this is still an issue, even if the statute is very clear and even if the court decision in People versus Butchie 40 years ago was really clear. And it could happen to different people in different kind of situations. So first, you could have an illegal split sentence, like the way it happened to Mr. Smith. And I think what's concerning in this case is that the sentencing court said she has done that before, she had no issue with it, and it was only a couple of years ago. So you could have illegal split sentence and then an issue at resentencing. You could also have a split sentence and a violation of probation that arise, and then the issue would be what sentence is available on a violation of probation. And so if the remedy in Mr. Smith's case was that credit for the jail term already applied to the probation sentence, then this would apply to a violation of probation. And it had most happen in this case because the sentencing court, she eventually vacated the probation, but she said that if she had found a violation of probation, she would have sentenced Mr. Smith to 1 year, which I think would also have been illegal because then he already served the year. So I think it could apply to other defendants on a violation of probation after a legal split sentence. And it could also apply in a third situation, which would be a legal split sentence with somebody who had some pretrial detention, and so the issue would be to take that into account, this already served prison term, to reduce the probation. So because it could apply to many different situations, I think that this court should have a look into it and apply the mootness exception.
Thank you very much.
Thank you.
May it please the court, Harmony Healy on behalf of the people. Justice Kern, you are correct. We did concede to the illegality of the sentence. With respect to Justice Lindley's question about whether or not this is something that is rampant out here, I did not practice. My trial experience doesn't come from Erie County, it comes from Jefferson County, but my appellate experience, I've never seen this come up before, so I would have to say that I don't think it's rampant. I guess that you guys would know better than I would know because you see every appeal that's coming out, but the ones that I've dealt with, I've never seen it. As I stated in my brief, I think the issue is moot because the defendant has served the sentence, and I think there was a question about the order of protection, and it was not preserved for the record. And if there are no other questions, then I would rest on my brief.
Thank you.
Thank you.
Justice, I have to say this, on behalf of the trial court of Erie County, I don't think it runs rampant there.
Is that okay?
Yeah.
Good to hear. We have case 209 is Zeta Chi Zeta Fraternity Incorporated versus SUNY Oswego.
Good afternoon, Your Honors. May it please the court. My name is Karen Felter. I'm an attorney at the Smith-Sovic office on behalf of the appellant petitioner Zeta Chi fraternity. It's hard for me to actually know where to begin here. It certainly is not lost on me or my client, the fraternity, several members of which actually have traveled from all over to be here today to listen to this argument. We certainly are aware that we are walking uphill. There's well-established, long-established case law in the state talking about the university's discretion to handle matters of educational policy and disciplinary matters as they see fit in accordance with their presumed authority on the issue of education. And so I know that courts are loath to get involved in these sorts of matters unless there's a really striking issue. And I guess the striking issue in this case for me and for my...
No, and the standard is substantial evidence, which I'm sure you explained here.
I did.
And you have admissions by the president.
Yeah, and I guess I'm just going to back up for 1 second before I answer that. The heart of our argument here is that the university was not the authority. That case law was, all issued and has been protected year after year, decade after decade in the state to protect the idea that universities are entitled to run their business the way that an educational institution should be run. And if there's a disciplinary matter, this court and others presume that the university is doing what it sees as necessary under the circumstances. I think here, you really have to question whether they're doing, the actions that they took in this case are something having to do with, changing their policy on fraternities. This is a backdoor way of getting rid of a fraternity, even though there's not any actual current and present violations that are noticed anywhere in the charges, in the record of the investigation, in the prosecution itself, in the decisions of the board, the disciplinary board, and the appellate board. So this was a prosecution of the historical history of alleged hazing violations by the fraternity, and yet there's no evidence of what the historical record of hazing is.
Right, well, you said earlier that we're loath to get involved in these cases. I'm not sure if that's the right word. It's not that I'm loath to, but our precedent and our rules of procedure that we've established don't allow us to, and our scope of review is quite limited.
Correct.
I don't even see the petition challenge that the evidence at the hearing, substantial evidence. I don't see that being. We have a lot of admissions here. I know that the president appeared, and there's a lot of admissions made. 5 so-called whistleblowers came, and I read your brief as number one, and your challenge is below, is there were some procedural irregularities. That's one thing we do, is did the school follow its own rules, procedural rules? That's the big one. And then your second issue is assuming that they did, and there's substantial evidence, is the penalty expulsion? Does it shock the conscience? Is it too severe of a penalty? So dealing with the first one, and mind you that we're limited to the objections, the legal procedural objections that were raised on administrative appeal. Do you have any procedural objections in your brief that you want to argue about today that were preserved in the administrative appeal?
Well, there were, I think, procedural objections raised concerning the manner in which the court, or the disciplinary board conducted the investigation and the prosecution on the basis of a complete absence of any evidence. However, to the extent that there's an argument that the objections to substantial evidence or due process or any of those sorts of things were waived because they were not raised at the hearing, there is the Court of Appeals case that I cited in the reply brief that talks about the fact that if there is a due process issue, that can overcome a failure to raise an issue in the administrative setting. And here,
What's that Court of Appeals case? Is that Sabine?
I'm sorry.
What's the name of the Court of Appeals case you're talking about?
Oh,
Okay, that's all right. I know.
I can't remember. It's in the.
That's fine.
It's in the
I'm sure it's there.
page 7 or something of
So
the reply.
what specific provisions of the Student Code of Counsel were violated here? I know there was some complaint about an anonymous complaint. Sounds like everybody knows who it was. It was a girlfriend of a member. Mm-hmm. You're saying that your clients, that your members of the fraternity didn't know who that complainant was?
No. I don't think that that's the argument at all.
Okay.
I don't think it matters whether they knew who she was or not.
Okay.
I think the point is that the sort of vague and unspecified contentions that she was making about the timeline in which these events supposedly occurred is non-existent.
All right, I just wanted to make sure I understood that you're not complaining that she was anonymous. You're not complaining that the 5 whistleblowers were anonymous. I'm sure they know who they are.
Oh, yeah.
Okay, so that's not a problem. All right, so
Yeah.
we've narrowed it to something else, that just vague and general allegations from them, from the anonymous, so-called anonymous informants isn't enough.
Yeah, I mean, so you start with the fact that there's, the charges themselves do talk about the fact that the fraternity is being prosecuted for its historical evidence of hazing, and yet that's not outlined anywhere. There's nowhere in the record where it outlines the dates or the history or prior violations. Not a single reference whatsoever, not even to non-hazing violations by this fraternity. So
There were a lot of admissions, right? There were some basically pleading guilty, if you will, in this context to a number of the charges, right? As far as misleading information, not answering truthfully the investigation, there was, you're not challenging the findings on those, right?
Well, actually, I think that the specific language that was used was not that they were misleading. They were, the specific thing that they were found responsible for was deceiving the university by denying information at the outset that was later admitted as true, which seems
Right,
crazy.
the allegation is they all got together, and there's evidence of it. They got together and say, hey, let's just all stonewall and deny. That seemed to have been the plan. Whether that's a violation of any of the rules of student conduct, I don't know, but that's what they alleged.
Right, but I mean, does that make any sense that, an individual or an entity that's charged with something has to tell the investigators every single thing that they know about the entire situation
Well, they
and
don't
not
have to
hold
lie about
anything
it.
back? Oh, I don't think that anybody lied. I don't think that's exactly my point.
They said they didn't know anything, and they did.
Well, I mean, they're
But
remaining,
is it-
exercising the right to remain silent, for lack of a better word, because I know this isn't a criminal case, but, they're
But does your
exercising.
point there go more to what the penalty is than what the findings are pretty clear.
Well-
Based on the evidence and the admissions.
Yeah.
So, but. we
But we're
get to-
talking about admissions to charges that are vague in and of themselves. So, there's a historical, a history here of this university engaging in, hazing. There's, it's been, through the years that people have, been subjected to humiliation, but there's no date, there's no details, there's no information about what this history is. That's
It's
the
mainly
premise.
hearsay. Hearsay from the president who, in his words, was trying to clean this all up and make changes, and
And what
I
does,
tend
what
to
does
agree.
what does this fraternity president know specifically
Right.
about these supposed decades of misconduct by other members who, aren't even at the university anymore?
Right, I understand, and nevertheless, there were a lot of admissions to violations. I agree with Justice Greenwood that this case is more about the penalty than the finding, and my
Yes.
review of this record,
Yeah.
if this is hazing, well, then there should be no fraternity on Oswego or anywhere else. I mean, this was,
But that's
this
exactly my
was, not
point.
that I condone any of this, okay? So I get that out there. But kind of mild. Holding a bag of ice while listening to Lou Gramm, Cold as Ice song, and pouring water on the head. I mean,
Hot sauce,
drinking
chocolate.
some, when I picked up the file, hazing, I'm expecting to see what we traditionally see as hazing.
Exactly.
See a lot, I mean, so I get, okay, they weren't forthcoming, I get some type of sanction, but there could have been a suspension with the opportunity to reapply. There's a number of fraternities at that school right now who are on suspension, and they're reapplying very soon. They chose to give this fraternity the death penalty.
Correct.
They are on unrecognized status right now, which means they can't ever come back for really seemingly mild hazing, albeit probably hazing under their rules, but, so now they can never come back for this? I mean, I don't know, it seemed a little shocking to me, but is it shocking that a fraternity has to go off school? I don't know, but it did seem like the penalty doesn't fit the crime here.
Well, obviously, that is the ultimate point that I'm reaching with this entire case, is that with absolutely no evidence of what the alleged, history of violations are, they're pointing to these sort of, juvenile events that were going
Nobody
on
was
at the
injured
fraternity.
ever. People voluntarily do it. Now, I know there's not a lot of choice when you're going through Hell Week, okay? But the worst thing, it seems, they put fluffernutter on them.
Is that your understanding, though? Because the suspension usually means you're suspended and then you are reinstated by just operation of the suspension. Is it your understanding in this particular case, because of the penalty, they may not reapply?
That is 100% true.
Is
And-
there, I don't know how it works at SUNY Geneseo. Can you have was there a fraternity house on campus?
It was.
So-
Well, no, actually, I
But
don't know the answer to that
So
question.
there,
I
yeah,
think they were
there's
in the
a lot
process of buying it.
whether the penalty is too severe, there's a lot of questions that I don't know. Is the house on campus? If it's not, that really doesn't hurt you so much because they're free to continue their fraternity off campus. They're not recognized, they can't do certain things on campus for recruitment, but if they're on campus and they're kicked out, that's a lot worse.
Well, it does have an impact, though, Your Honor, on, the value of that fraternity experience that all of these generations of members have had. That is part of, the credit that they earn when they're in the university. They are making personal and professional contacts with people.
They could still be in the fraternity, right?
And-
They probably are. We got a whole lot of them here that are probably still in the fraternity. They just can't, they're not recognized. So,
But that impacts their validity and their standing and their ability to recruit new members.
That's
And
true.
it will ultimately lead, unfortunately, to the real death of the fraternity, which I think is just entirely unwarranted here. I mean, there's no evidence that they ever were even warned, investigated, suspended, put on probation, charged with anything, ever. And so,
But
to
let me
your,
ask you a question, because the state may, and you don't get to, we're not the third part, so you can't, you're done after this. So I wanted to ask you about, they may cite a penal law section and say, yeah, but this was really a violation of 120:16, even though they weren't charged, so that's why the penalty doesn't shock the conscience. What do you say to that?
well, I think, first of all, that it doesn't rise to the level of the criminal charges because they literally couldn't have convicted them on the criminal charges, which is addressed specifically in both our original brief and our reply brief. If you look at the elements of those two provisions of the penal law, they would not be able to meet the elements of either one of them.
because there's no substantial risk of physical injury.
That's exactly right.
You don't get hurt if someone puts fluffernutter on you. You
I
don't
don't-
get hurt if they
I don't
pour
think so.
chocolate sauce on you. I guess the worst thing, I don't know, they had to drink some hot sauce,
Yes.
and one kid threw up the hot sauce.
Well, allegedly, there's a photograph that shows that he might have. You don't really know what that photograph means or
Could
when it
have
was
been the
taken.
beer he brought and drank on his own. I don't
Yeah.
know. That seems to be kind of tough. The fraternities that have been given unrecognized status, expelled, I think is the word they use, right?
Correct.
They're in that expelled category. There's others fraternities there too. There's other fraternities who were found to engage in misconduct and they're merely suspended, as Justice Greenwood said. Some are eligible to come back like soon.
I believe the language in the decision was that they were not eligible.
Right here, yeah, I agree with you. They
Which
are,
makes
they
no
are
sense.
in the expelled. They were given the death penalty. To see whether that shocks the conscience, it would seem to me we would need to know how does their misconduct compare to the other people who were given the death penalty as opposed to the people who were suspended, the fraternities who were suspended, or even the fraternities who weren't even suspended.
Well-
But there's nothing seemed to be in the record as, was it their hazing, if you can call it that, worse than the ones who were just suspended?
Well, I will say this. I think as a practical matter, I am not sure that that very specific issue was actually worked up at the level of the prosecution of the case and the defense of it by the student who was the representative. And I think perhaps the reason for that is that I think the fraternity organization was concerned about the well-being of the actual students who were also charged in this case.
Right, I guess my point,
And-
which you would probably agree with, that if, it's hard to have less mild hazing than this in a fraternity setting. Hard to conceive of less dangerous hazing, yet they suspended other fraternities for that. I don't know,
Where there
but
were
maybe it
pers-
wasn't hazing for
Where
that.
so then, when the organization appealed the determination of expulsion, they raised the fact that there had been other fraternities where actual people were injured. There was something with, I forget the name of the fraternity, and then there was a bunch of cheerleaders who had the same thing. People were actually injured or put in harm's way by the conduct, and yet no expulsion. So I think, I mean, my view of the conduct at issue here is that this fraternity scraped the bottom of the barrel to come up with some way to haze without hazing these students because it's the tradition and it's something that they enjoy
And not a
as long as
single,
people
not a
aren't getting
single
hurt.
pledge complained.
And nobody complained.
Nobody complained
And
then or
nobody was
ever.
hurt. And they
None
can't
of the
even.
parents of the pledges complained. It was an ex-girlfriend who filed the complaint.
And she didn't even say in her complaint that she made that the conduct that she was talking about was even ongoing. She talked about the fact that there was this history, and so that's what the whole prosecution was about. And I just think that what you said, Your Honor, is appropriate, that, if this is hazing, then there shouldn't be any fraternities on campus because they all do silly stuff. And that's what this is. It's silly. And the penalty for the first time offense of this nature of expulsion, I believe, does shock the conscience. And as I said, I think that this was a backdoor effort. Maybe it's the start of something like this at the university to get rid of these fraternities.
None of the fraternity members were expelled from school.
They were
None of
not.
the fraternity members were suspended from school.
They were not.
None of the members were disciplined in any way, shape, or form.
I don't believe so. I mean, that's not part of my case, so I don't know what happened to them.
I'm just saying, when it goes to the penalty, you think if what they did is so bad, like, why are they allowing them on campus?
Well, you know, in every fraternity hazing case I've ever been involved in, there's the ringleader, there's the group of leaders, there's the people that are running these things that take the responsibility, you know, and then of course, naturally, we want the organization to be held responsible for the, you know, unlawful, dangerous activities of members. But here, it's nonsensical. None of these people were actually punished for doing anything. And then as a result of unspecified historical hazing, they kick them off forever.
May I ask this question?
Yes, of
Did their
course.
national chapter suspend the local chapter?
I don't believe so. I don't even know, to tell you the truth, because the kid that was involved in this wasn't talking about it. I don't know if they're,
Well, it sounds like
it was even any sort of, I mean, I think the main, I don't even know what the relationship is between this fraternity and any other organization it's associated with, whether it's
it sounds like it's the
parent.
alums who are pushing this appeal, perhaps as much as the brothers.
Well, and as I explained, I think that there's a reason for that. This is an important, you know, nugget in the degree that they got and the experience that they had. And it's not just personal, it's professional. And, you know, I don't think it's fair to, you know, literally kill this organization based on the evidence that was presented to the disciplinary board. And especially because the appellate board said that this alleged conduct had been going on for some unspecified amount of time. I mean, the whole
We
thing is
understand.
just
You're
crazy.
Justice Finley, can I add
No,
this?
please do, yeah.
This is more a commentary, and I'm glad some of your clients are here. And I want your clients to know that we take this very seriously. We understand the importance of the college experience and their experience of unselfish living and putting service above yourself. So we totally understand that, and we understand why this is important to your clients and to yourself.
Thank you very much, Your Honor.
All right. Seeing that you're about 12 minutes over your argument, and I let you go.
It keeps happening to me
time
lately.
to-
I don't know, I just can't shut up.
time
Thank
to
you so
yield.
much.
So thank you, though. Ms. Rosenbluth, please.
Good morning, Your Honors. May it please the court. Can you hear me okay?
I'm sorry?
Can you hear me okay?
Oh, yes, we can. Thank you.
Okay, great. Sarah Rosenbluth for respondent. The question here is whether expelling the fraternity for conceded violations of the school's anti-hazing policy and after a conceded effort to mislead investigators is within the reasonable range of outcomes here. And I think the answer to that question is clearly yes. I just want to address a couple of the points that were...
But reasonable, that's not the standard. It shocks the conscience. is the
Well,
standard.
right. And I think if it's within the reasonable range of outcomes, it can't shock the conscience. And I certainly do submit that this does not shock the conscience. We're talking about, I heard my adversary say just now that if this is hazing, so let me just say, I don't disagree that this is a relatively mild instance of hazing. But I heard her now say, if this is hazing, what else could be hazing? But that's not what we're talking about here. The president admitted to a number of violations of the hazing policy.
Right, but Counselor, it appears that the penalties may be because they're accused of misleading the investigators, and that's why you got such an extreme penalty.
I mean, that's part of it. There were 16 charges that they were found responsible for, and 2 of them pertain to misleading the investigators. There's no discussion in the record about how to apportion blame exactly, but that's the totality of the circumstances here. conceded effort to mislead investigators and a conceded violation of the hazing policy that occurred as recently as 2 months prior with photographic evidence to boot. There's been a lot of discussion about, oh, there were no complaints, it only just came from the ex-girlfriend, and otherwise this is all very hazy sort of allegations, no pun intended. I think opposing counsel just said that they did, and it's reflected in the record that they did know who this person was. There's absolutely nothing stopping them from calling her as a witness at the hearing and testing her theory and poking holes in her account of events, but they simply did not do that here.
Right, well, they don't really dispute what happened. It doesn't sound like. I mean, there's pictures of in the basement there, and if what the fraternity did here was so bad that they should be expelled, that's your position. This was so, it was such serious misconduct, right?
If I can just, well, no, my position is that this is not necessarily the correct outcome, but it does not shock the conscience. That
Right, but what you're dealing with, what if they expelled each and every one of those kids involved in fraternity from school, and that was on their record, they got expelled? Would that shock the conscience?
I mean, perhaps, but that's an important factor. That's not what happened.
I know, but a fraternity does nothing except through its members. The fraternity doesn't do anything. It's actually a house and some symbols, some Greek symbols, and a national. The misconduct was by the members of the fraternity, as you say, coming up with this lie initially, doing the hazing, making them drink some hot sauce. Yet, you just said, but they weren't even charged individually, right? I think, or they weren't found guilty individually, and they weren't disciplined in any way. So, if it, as you just said, if it's possible that it would shock the conscience if they got expelled, then it does seem to militate in favor of a finding that expelling the fraternity, which again didn't do anything itself wrong, seems a little harsh here.
I disagree, Your Honor. A couple points. One is that I do believe it's true that the students weren't disciplined. I think it would be a much more severe sanction if individuals were permanently expelled from school and had this permanently on their academic record. But I don't believe that's the case here. And as a result, all we're left with is an impact to a non-human entity.
The impact is on these young men who can no longer be part of this fraternal organization that's recognized by the school. There will be an outlaw organization. Can't go on campus, can't recruit.
That's right. That's right.
So the effect is on them. I'm not, that's the effect, and look, it's
I
better.
understand, and
yeah.
I didn't mean to be flip. I mean, obviously there are human impacts here, but I just mean that the entity that's being expelled is the fraternity. When they're applying to jobs in the future, they don't have to show their transcript and say they were expelled. The actual sort of lasting harm in terms of impacts on employment opportunities and the like is not on the students, and I think that shows that this is not the harshest possible sanction. And then I also just want to make the point that there's been some suggestion that this is a disproportionate penalty, especially with regard to sanctions that were imposed on other organizations in the past. There's just nothing, first of all, that shouldn't matter. We should judge this on the facts of this case alone. And second of all, even if it did matter, there's nothing in the record to support that. And they had the opportunity to make that case, and they did try to make that case at Exhibit L, I believe, of the record at page 2, where they kind of just like briefly alluded to other organizations that quote unquote went through the judicial affairs process in regards to hazing and did not receive expulsions. But they didn't say anything about what they were or were not found responsible for doing. Or
I'm not sure they're privy to that information. But you just said a minute ago this was pretty mild hazing, right? You would acknowledge when we hear stories about, and we've had other cases. We hear stories about branding. We hear stories about forced consumption of alcohol. We hear kids dying, being beaten, physical. I mean, this is pretty mild compared to those, and as you acknowledge. So the ones that got suspended and not expelled, I'm having a hard time imagining like what that could have been. Like you just name call somebody and that's hazing.
I'm not here to debate what is and is not hazing. The facts of this case are that the president appeared at the hearing and willfully admitted that this was hazing, and he took responsibility ultimately for, I believe, 8 or 10 of the charges. So he didn't have to do that, and they could have built a much more robust case to show that they were not at fault, but they you know, clearly took responsibility for everything. So he said, we have to take account, we need to be held accountable for this. He said, we're trying to improve our track record, but it's been very slow, a very gradual phasing out process. The idea that they just, you know, have been totally clean hands in all this is not the case and not reflected by the record. I do think that obviously we're not dealing with people who died or had serious injury, but it is against the policy. They admitted it's against the policy. They admitted they lied about it. Is it within the range of reasonable outcomes to say they can't be recognized on campus anymore for violating the policy in this way? No, I don't think it is.
Ms. Rosenblum, we've got a case going back a couple years ago called Gray versus LaFountain, where our court modified the punishment under Pell. You cite the Bolt and about the shock to conscience standard, etc. So in Gray versus LaFountain, our court had modified the termination sanction for someone who purportedly took $181 out of I think it was the town's petty cash account. And that person was on the eve of retirement and had 28 years of service, and the town terminated that individual for that amount. And we modified the termination on the punishment and went up to the Court of Appeals, and we got reversed, saying that did not shock the conscience. Here, when the charges involve lying, allegedly.
Well, not allegedly.
Not allegedly, I take that back. Admittedly, lying to the investigators and doing so on a coordinated basis together with the other proof, I'm not so sure that if we tinker with the termination remedy or expulsion remedy, that the Court of Appeals is going to agree with us. They've been pretty strict with respect to the Pell standard of shock to conscience. It's a very narrow opportunity to change a punishment, and I'm not sure that it's present here. We'll see.
That's exactly right. I mean, and that's why I've been talking about the range of reasonable outcomes here. I mean, I think that the case law is clear that even if another person can look at this and say, this was pretty mild, as it sounds like you all are doing, which is reasonable, you might have given a different penalty. But the fact that the school administrators here gave the penalty that they did on the conceded facts, and again, there's concrete evidence in the record, and there keep being references that this is all speculative and unproven. I mean, that's just very strange when we have 6 students who testified at the hearing to their direct participation in these events, admittedly mild events, but they did do it as recently as 2 months before the hearing, and there's photos of it. So I think that this is not a case that shocks the conscience. It's completely unreasonable and irrational to reach the result that was reached here. And even if this court might have gone a different way in the first instance, it's really a very limited standard of review. So I would ask the court to confirm.
Thank you. Case number 210 is Wilmington Savings Fund Society, FSB, versus Gusten.
Good morning, Your Honors. May it please the Court, Kyle Dodone, Rupp Falsgraf, on behalf of Stephen and Pam Gustafson. Appellant seeks reversal of the trial court's decision in order granting a judgment of foreclosure and sale on a residential mortgage based on a misapplication of the statute of limitations and the doctrines of collateral estoppel and res judicata. First and foremost, with regard to the statute of limitations, there's no dispute that there was a notice of intent to accelerate the mortgage served in February of 2010. That notice, by its very content, indicates that the acceleration date shall be March 19th, 2010. That's in page 90 of the record. Now, with this notice, it is a valid acceleration of the entirety of the mortgage debt. This is something that the respondent disputes, but I think it's important to actually read the language within the notice, particularly the quote that if the default is not cured on or before March 19th, 2010, the mortgage payment will be accelerated with the full amount remaining accelerated and becoming due and payable in full. That is will. not might, not may, not perhaps, will. Now, the respondent argues it's not effective language to accelerate, but then I submit, why does the notice include the additional language stating that a borrower has the right to have the note and security agreement to remain fully effective as if immediate payment in full had never been required? That language is there because this was meant to be an acceleration notice, and it serves that purpose. It's clear from the case law, there are no special words to accelerate a mortgage note.
What, Counselor, you have to give a which dates, we have all kinds of dates here, and you have a ruling by the Supreme Court saying that it was invalid, so what are you specifically referring to?
Sure, and we're going to break that.
It's all relevant.
And I'm going to break that down as well. I believe it is relevant because there's a distinction that needs to be made,
right.
yes.
You need to explain.
Correct. So what we're addressing here is there's a 2005 mortgage. Following the creation of that mortgage, there is a notice of intent to accelerate, which was served by respondent's predecessor. At that point, the mortgage debt was accelerated in full, in its entirety. Therefore, with the 6-year statute of limitations, the statute of limitations began running on that effective date of March 19th, 2010.
Did the bank have standing to accelerate it then?
Yes, it did.
And it was a notice of acceleration, not an actual acceleration?
It's titled Notice of Acceleration, but it is the contents, not the label of the document, that is operative on whether or not it accelerates.
Yeah, can I just ask you some background facts? I know it's going to be wholly irrelevant, but make sure I want to understand what's going on here. Your clients borrowed $268,000 in March of 2005.
That's correct.
And there was a mortgage on the house.
Correct.
They defaulted in May of 2009.
Correct.
So we're now, what are we, 2025? So 16 years later, they're still living there?
Yes, they are.
And they haven't made a payment since March 1st, 2009?
They have not.
Not a penny?
No, they have not.
Okay. They paying the taxes?
I don't know if they're paying
So
the
they've
taxes.
been living, so we're in 16 years of not a penny for any of this. I mean, I just want to make sure I understood that. Okay. So you may continue.
So to address the timeline issue then, so in 2010, the mortgage debt is accelerated in full. Foreclosure action does not commence until 2012. That action was brought to foreclose upon the mortgage that had been accelerated by the notice. Through a motion, pre-answer motion to dismiss, that mortgage foreclosure action was dismissed based on a failure of the respondent's predecessor to demonstrate that it had standing to proceed with the action. Contrary to the respondent's assertion, standing does not equate to authority. Now, the trial court made a decision with regard to standing. It did not make a decision, and that is the distinction that the appellate brings before you today, is the distinction between standing and authority. Now, there was no demonstrated standing in the 2012 foreclosure case, but yet the predecessor did have authority as the assignee of the mortgage to make that acceleration notice.
But didn't this court already rule on this issue? That the loan was not accelerated?
And I was on that.
It ruled on the issue of standing, and because the court held because there is no standing, there is no acceleration. But our position is there are two separate issues that require distinction.
Mr. Denone, pardon me, but I'm reading the decision now. And as I say, I was on it. And it says, thus the entities that issued that notice of intent to accelerate, thus the entities' purported attempts to accelerate the entire debt were a nullity. And the 6-year statute of limitations did not begin to run on the entire debt. That's what we said in that case. I'm having great difficulty following your argument with respect to a distinction between standing and authority meaning anything, because we've already said that. So we would have to change that to agree with you, wouldn't we?
Well, the position that you're taking from that decision is an extension of the issue of standing. I'm not here to argue the issue of standing. What I'm issuing is the authority which the predecessor would have had at the time, because of its status as assignee. It was not a holder, it was not an owner of the note, and therefore it would not have had authority through standing. But that doesn't mean that it can't have authority through something else.
Yeah, I'm not sure that argument survives that broad statement I just read to you.
I understand, Your Honor.
Even if you had authority, and I'm not sure that you did, but even if you had authority, not you, but the plaintiff, but that says it's a nullity, and it did not begin to run.
In the context of the 2012 case.
Fair.
But in this particular case, I believe we were allowed to bring our separate position that there was in fact authority, which is demonstrated by demonstrating the assignment, that it was a true and proper acceleration.
That's what you want us to look at?
Yes, Your Honor. There are no special words to accelerate, must be clear and unequivocal. The notice does not provide any suggestion that, except for the payment, that the outstanding debt will be accelerated on that March 2010 date. Now, the two issues admittedly do bleed together, res judicata, the collateral estoppel. As I've mentioned, the appellant is not seeking to relitigate the standing issue. Appellant seeks merely to clarify the court's position in that the court holding in 2012 that the respondent lacked standing has no bearing on whether respondent had authority to send the notice of the intent to accelerate. As I've already mentioned, we believe those are two separate issues and the authority is valid. Now, there is a difference between a party that is not the holder and owner of the note and therefore no legal authority to accelerate the debt, and a party that is a holder and the owner of the note but fails to provide legally sufficient proof to the court at the time of commencement. And that's exactly what happened in 2012. Because they did not provide that legally sufficient proof to the court, it deprived the court of standing, and therefore it did not have authority to accelerate, or it does not invalidate the authority to accelerate the note. They're two separate issues. The court's decision conflates standing to sue with authority to accelerate the debt and demand payment in full. They're not the same, they shouldn't be treated the same, and that's why we asked the court to revisit that particular issue without application of res judicata or collateral estoppel. And with that, I ask the court to reverse the trial court's order and rest on our papers.
Thank you, Counselor.
Good morning. May it please the court, Manick of Knuckles and Manfro for the plaintiff respondent. Just to address the issue of this court's prior decision from April of 2018, the last paragraph does indicate that dealing with the Bank of America entity in between 2010 and 2012, that entity was not the holder or assignee of the mortgage. So I know the position that the appellant is taking now is that the Bank of America was the assignee, but the determination's already been made that that was not the case, and that's right in this court's decision from 2018. Generally, going back, the position or the arguments that we've made are basically that this case is the issues of statute of limitations and standing have already been addressed and are now the law of the case. But with respect to the statute of limitations, the Court of Appeals in Freedom versus Engel, which is that 2021 decision, indicated that a notice of default is not an acceleration of the debt because it's not clear and equivocal. You need an overt action, and the clearest form of that would be the commencement of an action. So in this case, this action was commenced in 2016. That was the acceleration of the loan. But even if we were to take 2012 as the acceleration, the first action, this action was commenced 4 years later, so it was timely. It was within the 6 years. So even if we were to look at 2012 as the acceleration date, this action is still timely.
What do you make of this argument that was made about the distinction between standing and authority?
Well, I mean, I'm not sure if that issue really came up in the motion or in the papers, in the underlying papers, but and that's what I was trying to point out is that the distinction that they're trying to make now is that a party may not have standing, but may be an assignee of the note and therefore has the authority. But that issue has already been addressed when with this court's decisions indicating that in between 2010 and 2012, when Bank of America was the alleged or at that time plaintiff in that action was indicating that they were the holder of the note. The prior action was dismissed because defendants or the appellant had argued in that case that Bank of America was neither the holder nor was it the assignee. So the arguments that they made in getting the 2012 action dismissed was that Bank of America had no standing, no authority at all. So relying on that, this new action had to be commenced. And now they're saying, well, maybe they didn't have standing, but they certainly had authority. So they've changed, but we can't go back and undo the dismissal of the 2012 action. And so that issue was addressed in 2016 when there was a pre-answer motion to dismiss, came up to this court. This court looked at the issues and determined that the 2012, there was no prior valid acceleration, either in 2010 or in 2012 with the commencement of the action, of that prior action, and therefore this current 2016 action was timely and not barred by the statute of limitations.
Thank you, Counsel.
Thank you.
Case 211 is Wilmont versus Krick. Good morning, Mr. Rosenhaus.
Morning, Your Honors.
We're back again for I lost count of how many times we've been here on this case, but this is our,
Yes.
we've been here before, so read the briefs, and I guess the first question would be, hasn't gone so well for your client in the previous appearances here, and maybe we got those wrong, but assuming that they're right, what's left here for you? And how does that affect your current appeal?
Well, of course, we are asking the court to reconsider its prior affirmances, but you're right, it does not affect the validity of this appeal, which is really from an order that modified the court's previous final order and did so in an unlawful manner and raises anew many questions from the previous order by virtue of the fact that a modified and a resettled judgment that changes substantially the prior judgment brings the prior judgment up for review again. So we think it's totally legitimate that this falls within the scope of review. And I would just make the argument with regard to the two judgments that the original judgment could not have afforded to the Hunter sisters, the prior owners of the property, could not have restored their title as a matter of law. They were not parties to that proceeding. They could not have benefited from it. If you look at it from the point of view of even the plain language of the court's decision itself assumes a continuation of the foreclosure proceeding, whereas the revised decision issued more recently assumes or purports to explain the prior decision completely unwound the foreclosure proceeding. So again, I think the key issue here for us is that this is a substantial modification. They brought in new parties. They afforded new relief. They did not merely expand on the prior order. They changed it. Therefore, the order is appealable and brings all the other issues up for review within this court, including the prior order to the extent that it's necessary to the final order. And that we seek
to rule for you on this appeal, do we have to revisit and change some of our rulings previously issued?
We don't think you have to, but we think
You would
the
like
court
us to,
should.
yeah, I mean,
Yes.
sure, that would be welcome. But is it required to reverse here?
It is not strictly required. For example, one could take the failure to join the necessary parties as a mandatory reversal, which I think it is under CPLR 1001. That's a mandatory reversal. You could remand it, but that is the point of discussing the proper disposition of this appeal. Is it a mere remand? Will not necessarily resolve the dispute. And we emphasize again, there is a serious jurisdiction and power issue that can be raised at any time, and which we are raising now, which we believe is strongly implicated in this proceeding.
All right. Anything further?
I have nothing further.
All right. Thank you, Counselor. Mr. Ballard.
Good morning. Todd Ballard from Harris Beach, Murtha, representing the Wilmont family. As the court's aware, I've been here 3 times. This time I'm here all alone. Prior to my appearance today, we had the attorney for the Hunter sisters here, and we had Adam Clark. And it could be alphabetically because Ballard's the only one left. Ballard, Clark, Johnson. So I think that I could see how you positioned us after the other foreclosure cases, which is very interesting. But the law of the case has to apply here for judicial economy, uniformity, and finality. And as we go through the law of the case, we have the October 21 trial court order. And that trial court order laid out a number of issues, and they resolved those issues very, very cleanly. The court can make declarations because foreclosure is equitable in nature. B, the court found statutory requirements with respect to notice were not met. And then C, and these are all in the record on appeal 39 through 47. I can go through all of the various factual points there. But the key is that the sale was vacated, the referee's deed was set aside, and a new foreclosure sale to be conducted with appropriate notice protocols. Very clean. And this court's affirmance in November of 2022 just adopted the law of the case that was rendered by the trial court. Then there was an Article 78 proceeding that was commenced by Mr. Krick, and the appellate court, this 4th Department, in December 2024, right? First of all, you decided various key issues that the trial court did not exceed her authority or jurisdiction. That was decided by this court. The second one was that the June 2023 order did not modify. It did not modify the judgment. It simply didn't. So the trial court recognized the fact that the 2021 judgment required title to revert back to the Hunter sisters. That's a matter of law. So there is no appealable issues here. This has gone up to the Court of Appeals for permission 2 times. We've had to file judicial inquiries 2 times, and it was rejected both times. And presently, we had to respond to a motion for leave to appeal that was recently filed, and we had to respond to that. So I just respectfully want to say to the court that there's a reason that you have finality. There's a reason that you have, the law of the case doctrine. And unfortunately, I've been practicing 38 years. There's a certain legal cynicism now. The court decides this, I don't care. Makes no sense. The court decided this issue, I simply don't care. I want to ignore it and just keep the barrage of litigation going. This case should end. There is no other interest that Mr. Krick has in this property, and I believe that the court's affirmance and the court's most recent decision should be followed in all respects. Thank you.
Thank you, Mr. Blair. Case 212 is F. James Maguire versus the Maguire Group Incorporated. Case 212. Brown, good morning.
Good morning. May it please the court. Megan Brown on behalf of the appellant, the Maguire Group. The trial court abused its discretion in denying the Maguire Group's motion for disqualification of the plaintiff's counsel because the facilities that Harder Seacrest represents in that other litigation are clearly affiliates of the Maguire Group.
You really need to get to the alter ego status, don't you, is what you argue in your brief, effectively?
Yeah. I mean, alter ego, affiliate, I mean, this is...
So would you stipulate,
Yes.
this is just a tough question, Ms. Brown, but would you stipulate that for all purposes, the Maguire Group and these facilities are alter egos under the law?
I'm not sure I have the ability to make that stipulation here.
The reason I ask it that way, and I appreciate your argument, this is where I kind of want to get to it.
Okay.
Is that it looks to me like this was very intentionally set up to keep these entities separate. And that typically happens for liability concerns, among others. So the contract between the facilities and the defendant here, because there is no direct concurrent conflict. It is only by virtue of the facilities, as I understand it. So the way you get there is going to be through that contract, but that contract seems to preserve very intentionally, as does the ownership structure, the separateness of these entities, contrary to that federal court case you rely on,
The GSI
where it's a wholly
case.
owned subsidiary.
Well,
I just aired it out for you to go at it.
Well, I disagree, Your Honor, because, there are certain public health regulations that govern how skilled nursing facilities have to be controlled and operated, and certainly various entities have tax reasons for why they structure things as they do. But what we have here is the Maguire Group, the sole shareholder is Mr. Farbenblum, and then through his entities also owns the facilities. And this is exactly the same structure that existed when Mr. Maguire owned the Maguire Group and the facilities. So this concept that they are separate, I think, is not true. In fact, Mr. Maguire signed those services agreements on behalf of both sides of the equation. So this is really not an arm's length transaction when he's saying, okay, I'm signing this as TMG and I'm signing it as the facilities. And the Maguire Group serves as the back office for all these facilities, and there's in-house counsel, and the conflict here is because, and that's why it became crystal clear during the discovery phase in this lawsuit, the conflict here is because when Harder Seacrest needs to get information or talk to its clients, i.e. the facilities, it talks to the Maguire Group. It talks to Mr. Farbenblum. It talks to the Maguire Group employees. The engagement letters that the court relied on were to officers of the Maguire Group. The Harder Seacrest has not talked to employees of the facilities. Everything goes through the Maguire Group. So I think despite the legal distinctions that exist, there are clearly affiliates here, and I think it very clearly implicates the language of Rule 1.7.
When would that conflict have been first known?
It would have been known when the lawsuit was commenced, I suppose, because the name on the complaint.
But the conflict wasn't pointed out then, was it?
It was not, but I appreciate you raising that, because that's certainly in my outline. There's no waiver by delay here or any sort of gamesmanship, and certainly the client takes issue with that characterization, because if you look back at the timeline, the amended answer was served in April of 2023. And then discovery began around June of 2023, and that's when it really became crystal clear, like, oh my goodness, the people you're gonna need to talk to are the same people that you represent, right? So then the Maguire Group's attorneys send a letter in July of 2023 saying, we have a conflict you have a conflict problem, you should step down from this. So the correspondence begins in July of 2023, following an amended answer in April 2023. That's pretty short period of time, busy schedules and everything. And then there, as the record contains, a flurry of communications and email correspondence back and forth on this issue. So nobody was sitting on it. It wasn't dormant. There's a further letter in October, the end of October 2023, saying, you know, we're following up, we're asking you to withdraw because of this conflict issue, or we're going to have to bring a motion. And there was already a December, I believe a December 11 conference on the calendar. So then with correspondence and communicating with the court, it was agreed, okay, we'll have the conference, and then at the conference they get the briefing scheduled for the motion. So the motion wasn't brought until December, but the issue was raised, formally raised back in July, and there had been extensive conversations about it, and Harder Seacrest had withdrawn from representation in the arbitration action that is going on sort of co-extensively with this one. So I don't think there was any sort of gamesmanship or delay when there was active communications going on and, you know, waiting to see what would happen in that case. So I don't think there can be any waiver of the conflict by those actions that were undertaken.
All right, anything further?
I just briefly would mention that I believe it was an abuse of discretion for Judge Kolyakovo to rely on the July 2023 engagement letter, which he does extensively in his decision, because that was clearly not accepted by Harder Seacrest. It's at page 306 of the record. I think it's Attorney Green says, we can't accept this, hang on while we figure out these conflict issues. So that really should not have provided any basis for the decision here. And unless there are further questions, I think we've spelled everything out in our briefs, and I'll rely on those.
Thank you.
Thank you.
Good morning.
Good morning. May it please the court. Lauren Mendelera for F. James Maguire. Before we jump into the specifics, I just wanted to outline for the court everything that the Maguire group has to prove here to get the relief they're looking for. The first is they've got to prove an abuse of discretion. That's not a standard that's at play in GSI or the other cases they cite. In those cases, they're affirming a lower court decision, not overturning it. So you've got abuse of discretion here, and that's especially hard with conflicts because there's such a wide breadth of discretion at the trial
Right,
court.
so even if we were to, maybe if we look at it, well, we would have gone the other way, it doesn't mean it's an abuse, and we can affirm even despite the fact that we might have ruled otherwise.
Correct, Your Honor.
What's your second point?
Second would be that there's a clear waiver here. There's decades of engagement letters with the facilities that clearly outline a waiver for any conflicts. And these are sophisticated parties. These are not individuals. These are parties who have been working with Harder Seacrest for years, who knew what they were waiving. The third would be the alter ego point that you made before. We don't even need to get to that if you go on waiver or you go on no abuse of discretion. But for alter egos here, exactly what the court pointed out, you've got contracts between the parties. That's what defines the relationship between the Maguire Group and the facilities. Those contracts say explicitly the Maguire Group is an independent contractor. Now
Right,
you
but
heard.
Would you agree that Mr. Farbenblum owns Maguire Group, and he owns some of those affiliates, some of those various nursing homes, right? He's common ownership there on some of them?
So
right?
I think you've got to go pretty far up the chain to believe that. If you look at the org chart.
You don't believe it? It's
Well,
not true?
If you look at the org chart that was submitted actually by the Maguire Group, you see the facilities aren't directly owned by Edward Farbenblum. They're owned by two separate entities called Vestor 1 and Vestor 2. Eventually that gets into shared ownership between Edward and his wife. So you've got to go through a couple layers. And I think that's significant because if you look at the practical implications here, how are lawyers supposed to do a conflict check before they decide they're going to represent a client? Do they have to ask all of their clients what their chain of ownership is and then check everybody in the chain of ownership?
You got Mr. Maguire, who's your client, right?
Yes.
He signs contracts both for the Maguire Group and for these affiliates, right? He's on both. That would trigger some concern there.
I don't see why it would, Your Honor. And I think what opposing counsel didn't mention is that this was all sold in 2017. So certainly there could have been contracts entered into between the new owner, Edward Farbenblum, and the facilities. He chose not to change any of that wording, and that's up to him to do. But we're looking at years, almost 10 years of ownership change since those took effect.
Right, and then your fourth point would be there's a strong preference that people can choose their own lawyers. Is that where you're going next?
Yes, Your Honor.
We're aware of that one.
What's that?
Yeah, we're aware of that, so you can get into your legal arguments now that you've established what the ground rules are.
Sure. As to the delay, I think it was a little bit disingenuous to look at that timeline. We have a concession now from opposing counsel that the conflict was known the moment the complaint was filed. You're talking January 2023 at that point. Not until 11 months later do you get a motion to disqualify. And the day that they sent a letter saying there's a conflict here is the same day that the facility signed new engagement letters with Harder Seacrest. So there's clearly no issue here. Conflicts are supposed to be situations where a lawyer just can't represent both clients, or there's confidential material that could be shared, right? Not only is the other side not saying that, they keep hiring us. They keep hiring Harder Seacrest and Emery. They clearly have no qualms about our ability to represent them because they keep signing our engagement letters. And they've never once alleged that Harder Seacrest got any confidential material or information about the facilities that could be used against them. The facilities aren't parties to this litigation. Harder Seacrest has never represented the Maguire Group, has never represented Edward Farman Bloom, which is another distinguishing factor for GSI. So we've just got a completely different scenario here. And by the time this court is hearing this, it's already 2+ years into the litigation, again, a distinction between this and GSI. And we're done with party discovery. All of those documents have already gone to Harder Seacrest and Emery, been analyzed, taking part in depositions. Party depositions are over. We're already speeding through this case at this point. And that's one of the factors that the courts consider, the prejudice here. You would be depriving Mr. Maguire of his counsel, who he's been using for decades, 2+ years into this litigation. That's a big deal. That's a big precedent to set. And like I said before, the Fourth Department doesn't have a lot of case law on this novel alter ego theory. That's why opposing counsel's relying on things like GSI and, you know, a Supreme Court case in New York from 2014 that kind of talks about it. And I think that any case law that comes out of this court is going to be really focused on for future conflicts. And I think to take that argument that opposing counsel is making and put it into an opinion would be to just expand conflicts beyond anything that the Fourth Department has done in the past and would just make it untenable at this point. It would just make it so hard for attorneys to know what conflicts are present. One of the things they mention is that TMG guarantees a loan for some of the facilities. So when lawyers take on new clients, do we have to ask who are their guarantors of their loans? And then when conflicts against them, do we have to ask every party they've contracted with and then do conflict checks against them? What if they change those contracts? Do we have to have an ongoing responsibility to look for who they're contracting with? And in terms of the alter ego theory, I think it's important. It was sort of skated by, but the regulatory implications, right? There's a regulatory reason that TMG and the facilities have to be treated as separate entities under the law, and that's significant. So is the fact that it's in a contract between the entities. If we're to say, well, the parties said in a contract they're independent, and the regs say they're independent, and the other side has admitted that that independence gets them tax advantages, but for conflicts purposes only, they are not independent. We can't allow an opposing party to choose that, to pick and choose like that. It's just not fair. And it's just not how conflicts should be.
All right. Thank you very much.
Thank you.
We'll move on to case 213, which is Bradley Garlo versus Sean Cunningham. Mr. Herzler, good morning to you.
Good morning, may it please the court. My name is Nicholas Herzler, and I represent the defendant appellant, Mr. Cunningham, in this case. Your Honors, the whole issue here is contract formation. And here's why I win on that issue. Because under this court's precedent of Himmelsbach and the Kevorkian case, case, and Lodi, which are prominently cited in our brief, all I need is a general release with the plaintiff's signature on it. That shifts the burden to my adversary to raise an issue of fact.
Well, they say, as you know, that when your client signed it on February 12, 2022, they signed the general release, it was modified from the one that was sent to them, right? It took out any reference to property damage. The carrier, Mercury, sent a general release to the plaintiff's lawyer saying we're going to settle for $100,000 inclusive of personal injury and property claims, two separate claims, right?
Yes.
The plaintiff signs it, but sends it back and redacts everything about property damage. He wanted money for his motorcycle separate and apart from his personal injury.
Correct.
So that gets sent back. It's a modified release, proposed modified release, because we don't know if the carrier's going to agree to that. Carrier offered $100,000 for both claims. Plaintiff says, no, I'll take $100,000 for one. So right now, we don't have a meeting of the minds. Are you with me so far?
I understand what Your Honor is saying.
All right, but then, okay, let me just, wait, you're going to say that they had a meeting of the minds on the personal injury action.
Correct.
But then when the adjuster gets it, Ms. Fenwick, the carrier, she calls and says, no, that's not, we're not agreeing to that. You get to take $100,000 for both. This is not acceptable. You sign it as we send, or we have no deal, right? Is that, maybe not word for word, I don't have a transcript here, but that's the gist of what was said, right?
Well, Your Honor, as I indicated in the beginning, like, the whole issue is contract formation. Like, we can't consider phone calls, we can't consider emails, we can't consider these things that are outside of the
All
agreement.
right, you may be right, but do I have the facts right so far as alleged? Fenwick says, no, I'm not taking it. You got to sign it as we send it, sign the release as I send it. This is what the allegation is from the lawyer. Fenwick, we have no responding affidavit, so she's not disputing it, but this is what the lawyer for the plaintiff says, right? That when she got it, you agree it was modified, right, by the plaintiff?
It was modified only in a certain limited
Right,
respect.
to take up property claim.
Correct.
So they said, we'll take $100,000 for the personal injury. We want our money for our motorcycle, right? So then it goes to the carrier, and the allegations, the carrier said, no, $100,000 for both, right? So far, so there's no meeting of the minds on that. You're saying, once they settled the property claim later, for whatever it was, $5,000, $7,000, whatever that was, then this became binding on the personal injury.
No, Your Honor.
And plaintiff can't change the mind, right?
What I'm saying is that everybody agreed to settle the bodily injury claim for $100,000. Everybody agreed to that.
Yeah, plus, but your client wanted to settle that for $100,000 plus the property damage claim.
There was a slight dispute about how much for the property damage
Right.
claim. That eventually got separately resolved, right? But the point is, the plaintiff signed a release for the injury claim.
How about, what if this happened? Same facts, the release comes over $100,000 just for personal injury, $100,000 for just personal injury. Plaintiff signs it but crosses it out and say, I want $200,000. Okay?
Right.
Then it goes back to the carrier. The carrier's like, you're crazy. I offered $100,000. I'm not. We don't have a deal.
Right.
And then subsequent things happen during the course of the case, like here.
Right. Your Honor.
And all of a sudden, $200,000 looks really good for the carrier. $200,000 looks really good for the carrier. The injuries get a lot worse, whatever. Is the plaintiff bound to accept the $200,000?
Your Honor, of course not, because look, what your hypothetical sheds light on, right, is that you have a disagreement about the bodily injury claim. If they, one number for the bodily injury claim is proposed, then there's a counter proposal to that. Here we have two parties agreeing to the $100,000 for the bodily injury claim.
Right.
That was
for one claim, but not the other. So we have a partial agreement on one, and you're saying they didn't have agreement on property damage. Once that was later resolved, both parties are locked in on the $100,000 for the personal injury, right?
Of course, because the plaintiff signed it and Mercury also put its stamp on it. And once they have that contract, there's a merger clause that says we're not going to talk about emails, we're not going to talk about phone calls, we're not going to talk about all these other things that are outside of the agreement. And the plaintiff admitted in his affidavit that he intended at the time in February of 22 to take $100,000 for his personal injury claim. He admits that. And so if this court were to rule in plaintiff's favor, it would be condoning a party who says, I agree to this something, I agree in a contract, and then a couple of months later, I've changed my mind. That's what he says in his affidavit.
I guess their position is, I can change my mind unless until we have a binding agreement. But why did your client, if they thought they had a settled with that release that was rejected by the carrier?
You're up.
Assuming the facts in the light most favorable to the plaintiff, right?
We're not in that posture here, Your Honor, because this, I mean.
Right, so you just want us to accept that it's untrue. What the plaintiff lawyer says, once the adjuster got the, or claims manager, we'll call her, Ms. Fenner, got the revised offer. She called and said, no, we don't agree with this. Right?
Your Honor, why I disagree with that is because under the case law, Lodi, MM, Kevorkian, and Himmelsbach, those cases say we need the plaintiff's signature. We don't need the adjuster's signature.
I agree. But you need a meeting of the mind, right? You can't have a plaintiff just unilaterally sign a release and then we have an agreement. The carrier's got to say, yeah, we're on board with that.
It has this Mercury stamp on it. And they prepare, and the case law says I don't need to have the carrier's signature on it.
Prior to it being modified.
It was modified for a term that has nothing to do with this dispute. We're here for a dispute over personal injury. We're not here for a dispute over the motorcycle. We paid for that. It's resolved. It's done. It's a pretext.
Right, no, I understand, yeah.
You made a motion to enforce the settlement and to compel the signature to a stipulation discontinuance with prejudice.
Correct.
But you still have a release.
Yes. I have a release.
What difference does it make? So if you lose this motion, you still have a release. You show up at trial or upon motion, and you say, I've got a release. Dismiss the personal injury action. I got that signature here. What do I need 2104 for?
Because they're continuing in the lower court with discovery. They're continuing to try to get other insurance policies involved. They're trying to, who knows, go after assets. Whatever the case may, they're trying to push this case, and we're saying this case should be over. We don't want to pay for discovery anymore. We don't want to litigate this case anymore. We settled it. It's over. Every claim is resolved. We paid for property damage, and we have a release for.
So you want us to decide in this appeal the validity of that release as to whether or not it represents a meeting of the minds of the parties for a portion of the action. Is that what you're asking us to do?
Yes, and I'm asking for the court to order a stipulation of discontinuance because that's what.
But if it's only for a portion of the action, as I just indicated, you can't get a stipulation of discontinuance because there's still a remaining claim within the case.
No, because the property damage was paid and settled and resolved.
So why don't you make a motion with respect to dismiss because it's paid?
Well, we're here because we can't get it dismissed because under the settlement rules, we have to get a stipulation of discontinuance.
So no matter how we look at it, what I'm trying to sort out is must we on this appeal decide the validity of the release vis-a-vis whether it constitutes a meeting of the minds in the exchange of memos, so to speak, as it's called, I think, in the contract formation language.
I guess the only other alternative would be to say we'll remand it to the lower court for a jury question on whether there was a meeting of the minds.
I'm not sure we do that in a motion for enforcement under 2104, but I see your point.
So if you're right, and I'm not saying you're wrong, because you make a lot of good legal arguments, and I haven't seen this before. So this seems to be relatively close, but if it went the other way, here was the plaintiff that changed his mind. His injuries, he claims got worse. There's only this is a $100,000 policy, so they're not getting any more out of the insurance company. But I guess they think they might be able to get some from the parents who own the car, and maybe there's some other policy out there. I think the carrier disclaimed coverage here, the other carrier, Progressive, for the kid didn't have permission, but be that it's made. Let's say it was the other way. $100,000 release is sent to the plaintiff for property damage and personal injury, and there's no agreement, same as we have here, and then it comes back. The carrier calls up the plaintiff's lawyer and says, no deal, 100 for both, or we're not going with it for just 100 on the personal injury. We want 100 for both. And okay, they start doing their thing. As the case goes through discovery, it becomes clear the case is worth not anywhere near 100. They come up with some defense, seatbelt defense, or they come up with other evidence that his injuries got better. Maybe he was faking it. You're saying in that situation, the plaintiff can come in and say, look, I know this case looks a lot worse for me, but I want my $100,000 now because I sent them a release and I get that $100 even though they told me no at the time.
Well, not only that, Your Honor, but there's a specific CPLR provision that says that if you have a release, then you can then enter judgment. You send it within 21 days if they don't pay. And so the plaintiff would be able to do that in that scenario because he has a signed general release. So it's a two-way street. We're just saying he's stuck with the release that he signed. I mean, if he wants to, if he was going to say it's an unconscionably low amount or something, that would be a whole different doctrine. They're not claiming mutual mistake, they're not claiming duress, they're not claiming fraud.
Right. Briefly, and I guess what Judge Curran, he put his finger on it, is that we have a meeting of the minds on Claim 1, not a meeting of the minds on Claim 2 when he signed the release. They later settled Claim 2. And therefore, Claim 1, the meeting of the minds should be enforced. That's your argument.
And by the way, in addition to that, he not only signed it, he also initialed it in 2 places.
Right.
I agree with this change. As long as the property damage is separated out, that's what the plaintiff agreed to. He's stuck with that. That's what the case law says.
Usually, it's common to separate property, get that dealt with separately than personal injury, right? Happens all the time.
I think frequently they're done with separate releases.
Okay.
In some cases.
We understand, and we'll take a very close look. It's an interesting issue.
Thank you for your time, Your Honor.
Thank you.
Good morning, Your Honor. Honors, if it please the court, John Collins for the plaintiff in this case. Supreme Court, I submit, was correct in denying the motion to enforce the settlement because that purported settlement is not enforceable because there was never a meeting of the minds as to the settlement terms. As the court already stated and synopsized, plaintiff rejected the carrier's proposal to settle all claims for $100,000, sent a revised release covering just the personal injury, and in response, as stated by Robert Corp of my firm, the claims adjuster, Nicole Fenwick, stated to him by telephone on February 24 of 2020 that the proposed modifications were not acceptable, and the two agreed that they would wait until the property damage claim had been resolved before re-engaging in efforts to resolve the PI claim. So essentially that modified release was sent conditionally, the condition being that the carrier found it acceptable in all respects. He was told by Ms. Fenwick, we don't, and they agreed that basically we're going to go back to square one after the property damage claim is settled. Nicole Fenwick, who had submitted an affidavit in support of the defendant's motion, did not submit any kind of reply affidavit disputing Mr. Corp's recitation of the agreements that he had come to with Ms. Fenwick. In fact, in her moving affidavit, Ms. Fenwick stated that Mercury never reneged on the bodily injury settlement. The $100,000 policy limits, quote, offer has remained in full force and effect. So she acknowledged that it, at that juncture, was an offer. And the reason it was an offer and not a fait accompli is the result of that 2020 phone call in which they agreed that basically everything's off the table. It's going to come back on the table after the property damage claim is resolved. And that's further borne out by the extensive correspondence generated by Ms. Fenwick and ultimately by defense counsel following that phone call. For example, in July, August, September 2022, Ms. Fenwick wrote to plaintiff's counsel asking him to sign the return release in order to resolve your client's bodily injury claim. If it had been in fact resolved, as defendant now claims, she wouldn't ask for a release in order to resolve it. In September 22, she also sent, quote, another release for your review. Upon receipt, payment will issue. So she's acknowledging there that the receipt of that first modified one was essentially a nullity. Otherwise, she wouldn't need a new release, which upon receipt would result in the issuance of payment. And then ultimately in February of 2023, defense counsel wrote to plaintiff's counsel saying, my understanding is the bodily injury suit is settled. Is my understanding correct? Again, that, acknowledged uncertainty and is just a concession and admission that settlement did not occur back in February of 2020.
4 proposed releases over a few months, from June to September 2022, asking for the release when they say now they already had a valid release.
Right. And, my contention is, and I would ask the court to accept it, that, sending those releases and saying, please sign the release and upon receipt we'll disperse the funds is an acknowledgement that the first modified release was, as Mr. Corp and Ms. Fenwick agreed back in February of 2020, a nullity, that had been sent conditionally.
Well, maybe they're just mistaken. I mean, she's claimed it. I mean, I don't think that's conclusive or anything, but we understand your point.
Yeah, so I think, Justice Farrelletto got it exactly right, that there had been no meeting of the minds. That's established by the record, and the release, as, the Carriers Insured's counsel has acknowledged, and adjuster has acknowledged, isn't valid in this case, and they keep looking for another release because there was in fact no settlement. And for that reason, I think the trial court's order should be affirmed.
Thank you, Counselor. Last case on the docket is 214. Last case for argument, I should say, is Edward Sandel versus Severin Development Incorporated. Ms. Tiverin is remote. Mr. DeMillo, did I say your name correctly?
It's DeMillo, Judge, thank you.
DeMillo is here. Thank you both for your patience this morning.
Good morning.
Ms. Tiverin, you may proceed.
Thank you very much, and good morning. Just as the court is aware, I represent Severin Development Incorporated, and we're simply asking that the court allow our client's case to go forward on the merits as opposed to a default. Very straightforward argument, Your Honors. It's simply that in addition to the policy of the Fourth Department to avoid having matters considered on default rather than the merits, we take the position that there was excusable default with respect to answering in this matter.
What was you're referring to law office failure?
Yes, Your Honor. The answer was submitted 16 days late. There was, we have compartmentalization in our office. There's a real estate group and there's a litigation group. And
right, but look, Mr. DeMillo is going to get up here in a couple minutes and say you didn't make that argument below, it's unpreserved.
I believe that
the argument below was not law office failure. It was we were negotiating, and that's why we didn't answer.
I think though that we did argue it before Judge Sedita, and I think if the court could look at the record, obviously if we submitted it late, that there was law office failure in that regard, and because of that, our client should not be barred from arguing the merits of their position, which is that the.
Could you just point? And I'm not saying you're wrong. Okay, I don't remember seeing it. Could you point where that might be, or if you don't have it handy, maybe in a post-argument submission, where the issue of law office failure for not answering in time was preserved?
I would need to do it on a post-motion.
That's fine. Yeah, that's fine. Thank you.
Thank you.
And it sounds like there might have been law office failure and not alleging law office failure.
There was law office failure, clearly. I mean,
a couple of layers, but all right.
And I think that if one looks at the totality of the record, the legal argument that can be made can be brought at the first instance on the appellate argument. We're not necessarily limited, but it was.
How's that? How do you? What basis do you say that?
It was in our reply brief. Your Honor. There was a
case
given for that.
Yeah, we've done that many times. The Court of Appeals reversed us recently in a case called Sabine, and causes us to think whether we can actually do that ever again. But that's Oren versus Capone is the case we cite all the time for that. You cited some other cases that cite it, but Yeah, look at Sabine, it's a recent case, and I'm not sure we have that authority on unpreserved issues anymore unless we do it in the furtherance of justice. But in any event, so we've got, do you want to be heard on this issue of there were ongoing negotiations and that was a justification, that's an excuse? Kind of hard when the negotiations started, it looks like after the deadline was due for the.
I think there were some discussions beforehand. Candidly, they were, we were asked basically for the return of the deposit, and we refused it. I know that is thin, but it is offered as part of our efforts to try to move forward. Our real estate group was, intending on working forward through the question. The Sandel's council had asked for an enumeration of the amounts that should be deducted from the deposit before its return, recognizing that there would have been expenses that our client extended and incurred.
Right, but once the number reached over 25,000, I think it was rejected, and it looked like the negotiation stopped until it was too late. So that's one of the arguments they're going to make, and since you can't rebut it, do you want to address that now? About that time period in the middle there where there doesn't seem to be in the record anyway any negotiations.
Your Honor, I'm not going to fabricate something, only I can't do that, only to indicate that
I'm glad you're not fabricating.
We don't encourage fabrication.
Well, only that, the matter is with our office. We do have, attorneys that are involved. The defendant in this particular case is, not unrepresented. There are conversations that can be had. Yes, there were discussions afterwards. I can't account for that space in the middle other than I've already have, which is, again, it moved from one department to another. Obviously not cleanly, but I simply am asking that, given those circumstances, our client should not be, just prevented from recouping expenses that it validly incurred in order to make this contract work for the plaintiff. It was a new build contract. They were going forward, as is the custom. And I know that there is mention made of the lack of the failure of the contingency, but I think that that's disingenuous. I think that anytime there is a new build that's contracted for, even if it's contingent on the closing of the underlying real property contract, work commences. People want to get going on their new build. They want to get going on the work that needs to be done, and they don't want things delayed. So my client did that. And again, in this particular case, the merits or the merits that were argued as far as the meritorious defense stand. There is a defense, and there are damages to my client, and he should be allowed to proceed.
Your client's defense to the argument on the closing contingency from paragraph 41, it talks about this contract's contingent on parties entered into a binding contract. The other one, and the closing thereof. I guess your argument there is that there's this prevention doctrine that if you don't close, if a condition precedent doesn't occur because it's your own fault, you can't rely on it. Is that?
Yes.
That's really what the defense is here?
It is. I guess I'm also saying, Your Honor, that yes, that is and it's as outlined in our brief. I think though that again, I'm raising to the court the practical reality that when a new build contract is entered into, work starts on it immediately. So, to say that the closing didn't occur is both prevented by the doctrine that we cited, but also as a practical matter.
Well, if the work started immediately, you got all those. I mean, the $20,000 deposit wasn't required by anything. It was just kind of a gratuitous payment here outside the contract, right? So if it weren't for that, this case would have been worth what, $6,000?
Or $5,000, but perhaps, but the fact of the matter, it was provided, and the work, and there was
Yeah,
work
no, I understand. Done. Yeah, I understand. All right, well, we appreciate it. And if you want to submit post-argument submission on the issue of preservation of loss failure, we will certainly look at that within the time frame required by our rules. Thank you.
Good afternoon, Your Honor. Angelo DeMillo, I represent the plaintiffs Rosanna and Edward Sandel. They are in the courtroom here today. The issue is very narrow, I think the court has pointed out. I've been with this case. I was the attorney for my sister throughout the entire process. So something that was said here in terms of work that was done before, and there's other clause in the contract that no construction shall occur until we obtain title. So when they say we're doing all this work, there wasn't all that work. So when we finally said we're done, we started a lawsuit. After we started it, there was no answer. I'm the one that called their attention to the fact there's no answer.
If you had an answer, Lord knows how long it would have gone.
Right, right.
Could have gone months, weeks, years, you never know.
So there's no answer. I sent 4 separate emails to different attorneys before Mr. Cohen, warning them, I'm not going to accept a late answer. September 5th, I'm not going to accept a late answer. September 6th, I'm not going to accept a late answer. September 11th, you're in default, I'm going to file for a motion. They didn't do anything, nothing. They just ignore me, just, you know what, fine. I'm the one that put forth the 20 grand. I said, look, you probably did plans. I got it. Give us 20, keep 5, we're done. Their position from the beginning has been, we take it all. We take it all. And then they throw in that fabricated expense sheet, performance costs. And I challenged that. I said, wait a minute. Half the stuff was before we even signed the contract. Some of it, $275 for secretarial work. Crazy stuff.
Would you agree with me on this? It doesn't mean you necessarily lose if you would agree, but you engaged in some negotiations with Mr. Kelleher before Mr. Cohen got involved. There was some back and forth there, and then you said a letter, you remained hopeful that a reasonable settlement can be worked out. That was in June of 2023. It sounds like there was an idea of like, okay, if you actually have some legitimate expenses that you can take out of the money, go ahead.
Exactly.
That's settlement, right?
Well, here's what happens. The first response was, we'll agree to release you from the contract. We keep the whole 25 grand. That's how it started. And I said, no, if you have some performance costs, get them to me. If they're reasonable, we'll get this thing resolved. Okay? And then it just dragged on. I just felt stonewalled the entire time.
But there was some settlement negotiation.
There was some, I'll call them.
But then they terminated when you filed the complaint.
Before that. I filed it August 7th, before that was done. From the critical time period, August 7th to August 28th, nothing. Silent, crickets, zero. Heard nothing. And then I tell them, hey, you're in default. Oh, we didn't even know that. We had the wrong timeline. Well, wait, that's not my problem. I tell them, I'm not going to accept your answer. 3 times. Then they file the answer. Did they decide to go to the court and get permission to file it? No. They ignore me. I would think they would have filed a motion. Hey, listen, we got problems here. A, excusable neglect. If you want to make up ongoing negotiations, fine. But
Lawful failure.
Lawful failure.
That would be legitimate under the new statute, well, relatively new statute. This was classic, arguably could be classic lawful failure.
It could be, but you have to put forth affidavits. And then the court will say, I got it, that is excusable. There are cases where it's not excusable lawful failure. So just saying it doesn't make it happen. They want a free pass. They want to say, and then they file the answer. I reject the answer. They don't file the motion. After that, I say on September 14th, your answer rejected. Look, let's get this done. Let us keep the 20, keep 5, we're done. Then we want 9,000. You keep 9. It got insane.
Yeah.
And then I filed a motion, and then I hear ongoing negotiations. You know, Judge Sedita, to his credit, took his time and outlined exactly the time frame this went down. And the point that was made earlier was this lawful failure. It was never raised in the pleadings. Zero. In fact, at that time, on page 16, the attorney then, this is like, I've had 4 different attorneys representing the defendant. It's not just one. You get Mike Kelleher, you get Steve Cohen, you get the attorney Sabirin Gerber at the motion, and now you got Diane Tevron. But at the motion, she says, but he is relying on the fact that within the time, although he did not file our answer, he was trying to negotiate during that time to lower litigation costs, and he believed that he was in active negotiations with countering, and he was trying to work it out amicably. Well, that doesn't tell me lawful failure. That's the attorney at the argument stage. So did Judge Sedita abuse his discretion? No, he called it what it was.
Well, he was pretty strict about, the law says this, the law says that. That was true back in the day. It's not so true. There's a little more flexibility in the statute, but we understand your point, and we'll take a look at your
Thank you.
brief further and have a ruling for you in due time.
Thank you very much. Thank you.
Thank you.